a short while. We are expecting the guests who are a bit delayed because of a high-power committee meeting of the High Court of Delhi. And our chief guests are likely to arrive soon. Sorry for the inconvenience being caused to each one of you present here. We have just received the message that the meeting is over, and soon our chief guest is likely to arrive. Meanwhile, we are sorry for the inconvenience being caused to all of you, and soon we are going to start the proceedings. For the lawyers present here, we can all appreciate how things happen in courts when yours is the next number and you keep waiting from morning till evening. So we all are very attuned to this system. But for non-lawyers, I will say sorry, we are keeping you waiting for this purpose. But then we just wanted you to have a taste of our patience as well. Thank you and sorry for the inconvenience.
उठ नहीं सकूंगा वहां से, इसलिए मैं रिक्वेस्ट करता हूँ, आज मैं हाथ जोड़ रहा हूँ।
Good evening. We welcome our chief guest, Honorable Mr. Justice Suresh Kait. We welcome Honorable Mr. Justice Anup Bhambhani. We welcome Mr. Adish Aggarwala, President, Supreme Court Bar Association. We welcome Mr. Mohit Mathur, President, Delhi High Court Bar Association. We would request Dr. Reeta, Vasishta, Member Secretary, Law Commission of India, to kindly join on the stage. We would request Additional Solicitor General Mr. Chetan Sharma to kindly we request Professor Dr. Vageshwari Deswal. Please. Welcome. Good evening and welcome to the distinguished dignitaries on the dais and Honorable Mr. Justice Manoj Jain, our senior, our teacher and mentor, Mr. APS Ahluwalia, senior advocate, our senior and mentor, Dr. Arun Mohan, senior advocate. We welcome Mr. Rajiv Bahal, one of the senior most advocate of Delhi High Court, other senior advocates of the Delhi High Court, members of the Delhi High Court Bar Association. We welcome Honorable Mr. Justice Jaspreet Singh. We welcome Mr. Harrier. I think I should retire if I forget your name. Welcome to this evening, to the book launch, to the launch of the books authored by our fraternal brother, Mr. Saurabh Kansal, with two of his teachers, I would say, Professor Dr. Vageshwari Deswal and Dr. Reeta Vasishta. Thank you very much. Friends, the yearning for a fast, efficient, and scientifically oriented, technology-infused legal system resulted in a major amendments to both criminal and civil procedure, being both remarkably impacted by evidence mechanism in the country. The zeal to have an efficient, speedy justice delivery system, overcoming the shortfalls in a complex legal procedure, inadequate use of forensic sciences, and above all, the urge to have a very independent, India-centric code of procedure for legal system have led to the advancement in the legal system in the country, and the current amendments to the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act are the outcome of the said, I would say, urge for both the center, the government, and the judiciary, as well as the bar. There had been a long debate on the amendments proposed, their intent and purpose, and all this has been riddled with anxiety and apprehensions about their impact on the legal system and the procedural mechanism of law. However, putting an end to this debate and providing a comparative insight to the amendments came the three books now today going to be revealed by the August gathering here. We welcome Mr. Justice Saurabh Banerjee. Good evening, sir. To start with the proceedings, I would request the volunteers to kindly be ready to present our mark of respect and our green love, some planters to our guests and the dignitaries and sitting in the auditorium. I would request in the first instance, Mr. APS Ahluwalia, the senior advocate, to kindly present. Sir, you can come from this side. A planter to Honorable Mr. Justice Suresh Kait. Please. I would request Mr. Sunil Mittal, Senior Advocate, to kindly proceed to the stage and present a planter to Honorable Mr. Justice Anup Bhambhani. I would request Mr. Anuj Rajwanshi to kindly present the bouquet to Honorable Mr. Justice Jasmeet Singh. Please, sir. I would request Mr. Rajiv Behel, the Senior Advocate, Senior Most Advocate, I would say, to kindly present a planter to Honorable Mr. Justice Manoj Jain. Sir. Right. I would request Mr. Satendra Singh Bawa to please present a planter to Honorable Mr. Justice Saurabh Banerjee. नीचे लेके जाओ बेटा. I would request Mr. Rakesh Tikku to kindly proceed to the stage and present a planter to our Additional Solicitor General, Mr. Chetan Sharma. I would request my daughter, Megha Saxena. I am told to do that. To present a bouquet to none other than our own President, Mr. Mohit Mathur. I would request Mr. Sukham Aluwalia to present a planter to Mr. Adish Aggarwala, President, Supreme Court Bar Association, one of the most effective and lovable President of the Bar. And on a very rare occasion, we come across when the wives really appreciate the work put in by their husbands. And for this, to acknowledge this, I request none other than Pallavi Sharma Kansal to present a bouquet, a planter, to the author of the books, Mr. Saurabh Kansal. A warm round of applause. This is the privilege of the anchor. Please. To start with the proceedings of the evening, the authors of the books are here, along with I would request Ms. Vidhi Gupta to kindly proceed to the stage to present a planter to Professor Dr. to present a planter to Professor Dr. Vageshwari Deswal. I would request Mr. Ansh Bhargava to kindly proceed to the stage and present a planter to Dr. Reeta Vasishta, Member Secretary, Law Commission of India. Friends, it's a momentous occasion for me to anchor this at this evening function, not just because I have been given an opportunity to anchor this proceedings here, but more because the function relates to a fraternal younger brother, Mr. Saurabh Kansal, who has labored hard to write these books under the tutelage of two of the very brilliant professors, Dr. Reeta Vasishta and Professor Dr. Vageshwari Deswal. A big round of applause for our fraternal brother. I would now request Dr. Reeta Vasishta to kindly acquaint the member, the August gathering here, with the legislative intent behind the introduction of these new criminal laws. Please, Dr. With a big round of applause for Dr. Reeta Vasishta. Please.
Honorable Mr. Justice Suresh Kumar Kait, Judge, High Court of Delhi, Honorable Mr. Justice A.J. Bhambhani, Judge, High Court of Delhi, Shri Chetan Sharma, Additional Solicitor General, Shri Adish Aggarwala, President, Supreme Court Bar Association, Shri Mohit Mathur, President, Delhi High Court Bar Association, Professor Vageshwari Deswal, and Saurabh ji, and the August gathering. Ladies and gentlemen, a very good evening to all of you. At the outset, I would like to thank the organizers for inviting me to this book launch function. I congratulate Mr. Saurabh Kansal, Professor Vageshwari Deswal, and Dr. Shruti Goyal, the authors of these books on the 3 new laws, criminal laws. They have worked hard on these books and ensured that these are published even before these laws come into force on 1st July 2024. Incidentally, I am pleased to share with you that these laws were drafted by me as Legislative Secretary and my team, consisting of Joint Secretary Shri Diwakar Singh, Deputy Secretaries V.K. Mishra, Shri Shashi Bhushan, Shri A.K. Dubey, and Additional Legislative Council Shri R.K. Patnaik. We were assisted in our work by PAs Shri Shashi Bhushan, Shri Ajayan, and Shri Dakshinamurthy. I wholeheartedly appreciate their efforts. Above all, I must acknowledge the tremendous support of our Honorable Minister, Shri Arjun Ram Meghwal ji, whom we used to disturb even past midnight, even when the drafting of these laws was in progress. Writing a book is a long and often solitary process, and it's the people around us who provide the motivation and inspiration to keep going. These newly published books highlight all the major changes made in the new criminal laws and also make a comparison of provisions of old laws with newly enacted laws in a tabular form, which makes it easier to comprehend. The replacement for the Indian Penal Code, namely Bharatiya Nyaya Sanhita, introduces a nuanced approach to offenses. BNS is a transformation of the criminal justice system to make it more efficient, transparent, and accessible, and to move from the ideal of dand, that is punishment, to Nyay, that is justice. Further, the Bharatiya Nyay Nagrik Suraksha Sanhita, which replaces the CRPC, seeks to make justice more accessible and speedier with the use of technology and forensic sciences in investigations. Furthermore, Bharatiya Sakshi Adhiniyam, which replaces Indian Evidence Act, focuses on admissibility of electronic evidence with changes to the definition of document and evidence to include electronic or digital records. The legislative intent behind making these laws are, firstly, to modernize and reform the criminal justice system. The colonial era Indian Penal Code, Code of Criminal Procedure, and Indian Evidence Act had become outdated and were no longer aligned with the contemporary needs and values of Indian society. The new laws aim to address the shortcomings of these outdated laws and bring the criminal justice system in line with modern standards. Secondly, to enhance protection for general public. The new laws have placed a strong emphasis on protecting the rights of general public, particularly the poor, marginalized, and vulnerable sections of society. They aim to streamline criminal justice process, ensure speedy trials, and provide greater safeguards for victims of crime. Thirdly, crack down on organized crime and terrorism. The new laws have introduced stricter measures to combat organized crime, terrorism, and other serious offenses. They aim to strengthen law enforcement agencies, enhance investigative capabilities, and provide for more effective prosecution of criminals. Fourthly, to promote efficiency and transparency. The new laws seek to introduce greater efficiency and transparency in the criminal justice system. They aim to digitize many aspects of the criminal justice process, from filing first information reports to issuing summons and delivering judgments. Fifthly, to align with international standards. The new laws are also intended to align India's criminal justice system with international standards and best practices. This aims to improve India's standing in the global community and enhance its ability to combat transnational crimes. Overall, the introduction of Bharatiya Nyay Sanhita, the Bharatiya Nagrik Suraksha Sanhita, and the Bharatiya Sakshi Adhiniyam represent a significant step towards modernizing and reforming India's criminal justice system. The effectiveness of this reform hinges on meticulous execution, well-defined directives, and ongoing oversight to ensure that legislation achieves its intended goals without unforeseen repercussions. At the end, I would again like to congratulate Mr. Saurabh Kansal, Professor Vageshwari, Deswal, and Dr. Shruti Goyal for promptly releasing books on the newly enacted revolutionary criminal justice laws even before the enforcement of these laws. I must also appreciate the Taxmann publications to launch this first-of-its-kind book so swiftly. It's been an honor to be among such accomplished individuals and to be able to present my perspective before you all. Thank you. Jai Hind.
Thank you, Dr. Vasishta, for the enlightenment with regard to the publication of the book and the source, how it developed. We welcome amongst us Honorable Mr. Justice Jagjeevan Ram Midda, the mentor and the first senior of our author, Mr. Saurabh Kansal. And I request Mr. Abhilash Mathur to present a planter to Honorable Mr. Justice Midda. Justice Midda, may I request Mr. Mathur to also escort Mr. Midda to either please join us on the stage. Sir, it will be an honor, not only for me, but for Mr. Saurabh Kansal, the author of the book, as well, to have his mentor by his side. पैर छू करके सौरभ
मिस्टर सौरभ पैर छू ऐसे
Please, I would request Saurabh Kansal to stay there and present a planter to his mentor and senior, Dr. Arun Mohan.
दूसरा फोटो हाँ ये फोटो
I would request Mr. Snehanshis. Sorry. Oh, sorry. Please, sir. To present a bouquet to Dr. Shruti Goyal. A planter, please. Here. The co-author with
जरा इधर आओ बीच में आओ जरा हमारा भी फोटो फोटोग्राफ उधर से ले भैया गलत ले रहा फोटो ऐसे नहीं
with
उधर इधर
welcome Dr. Goyal and thanks.
हाँ ऐसे लो हमारा भी आना चाहिए पता नहीं चला किसके सामने लिया है.
I would now request the co-author of the book, Professor Dr. Vageshwari Deswal, to kindly enlighten the gathering here.
You can use that mic also.
Honorable Justice Suresh Kait, Honorable Justice Anup Jairam Bhambhani, ASG Shri Chetan Sharma ji, respected Madam Dr. Reeta Vasishta, Dr. Adish Aggarwala, Advocate Mohit Mathur, Advocate Rajiv Saxena, my co-author, Advocate Saurabh Kansal and Dr. Shruti Goyal, my revered teacher, Professor KPS Mehalwarji, my brother, Dr. Vikram, all the respected dignitaries, revered guests from the bench, bar, academia, law researchers, my colleagues, and dear students. Good evening to all. This is a momentous occasion as we gather here today to celebrate the launch of Bharat's first comprehensive books on the 3 new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam. These laws have replaced the old and archaic criminal laws that were enacted by our colonial masters in the 19th century for their subjects. The objective behind the old laws was to punish those who dared to transgress the norms established by these imperial rulers, hence the title Indian Penal Code. The other law, CRPC, simply laid down the procedure to be followed for apprehending, trying, and punishing those offenders. To quote the Greek philosopher Heraclitus, the only constant in life is change. Society changes, and laws need to keep pace with the changing times. Many detractors have tried to run down the new laws by calling the changes merely cosmetic or akin to presentation of old wine in new bottle. Please do not pay attention to them. The change is substantial. Okay. These 3 new laws have been drafted, keeping in mind the contemporary needs of our society. Further, these have been enacted by our democratically elected leaders for their own people. Thus, the objective is justice. There is a shift from penal code to Nyaya Sanhita. In criminal justice system, punishment to the offender does not necessarily translate into justice for the victim. Our reformative approach towards offenders makes room for restorative principles of justice in the new laws by introducing community service as a kind of punishment. Bharatiya Nyaya Sanhita has been restructured and reorganized systematically. Some new provisions have been added to deal with crimes such as mob lynchings, honor killings, hate crimes, love jihad, raping a woman by obtaining consent fraudulently, organized crime, terrorist acts, attempt to commit suicide has been decriminalized in accordance with the Mental Health Care Act, but attempting suicide to prevent a public servant from performing his duty has been introduced as a crime. Sedition has been changed to treason, and it is no longer a strict liability crime. In order to incorporate various Supreme Court judgments and changes ushered in by other enactments, crimes such as adultery and homosexuality have been effaced from the statute books. Age of marital rape exemption has been increased to the woman being not less than 18 years of age. Certain crimes have changed form. For example, earlier theft could take place only of tangible movable property, but the amended definition of movable property in BNS includes intangible property too. So now we can deal with instances of data theft. Transgenders were recognized as humans in 2019 by the Transgender Persons Protection of Rights Act. BNS expands the definition of persons to include man, woman, as well as trans persons. Similarly, we use gender-neutral term child instead of using minor girl or minor boy. Crimes of voyeurism, stalking, they have been made partially gender-neutral in the sense that the perpetrator can be any person, whereas the victim can only be a woman. Stigmatizing terms such as lunatic, idiot, they have been removed. Terms referring to colonial era, such as the British calendar, Queen, British India, they have been removed. Coming to BNSS, the objective of this new law is protection of our citizens. Audio, video, electronic means, videography, forensic examination, specified timelines, they have all been introduced for effective and speedy dispensation of justice. The new law has defined bail, bail bond, electronic communication. We have expanded the definition of the term victim. We have replaced the term pleader with advocate. Terms such as metropolitan magistrates, assistant sessions judge, they have been removed. There have been comprehensive reforms in Directorate of Prosecution that will work at district level too. Zero FIR, EFIRs, and many more changes have been brought in to make it contemporary. In BSA also, 2 new sections and 6 new subsections have been added. 6 old sections have been removed. Definition of evidence has been expanded to include electronic and digital records. They will have the same legal effect, value, and admissibility as other documents and are to be treated as primary evidence. There are multiple other minor changes also, all of which cannot be talked about in the 5 minutes that have been allotted to me. So I and my young and dynamic co-authors, Advocate Saurabh Kansal and Dr. Shruti Goyal, have been closely following and working upon the new laws ever since the 3 new criminal law bills were introduced in August 2023 and thereafter when their revised versions were reintroduced in December. It has been our endeavor to analyze all the provisions in detail, provide a comparative analysis with the old laws, draw linkages with related provisions under other laws, and compile relevant and the most recent of judicial pronouncements. Wherever required, we have quoted extracts from legislative debates and parliamentary reports too. While I and Dr. Shruti have tried to bring in an academic orientation in analyzing these laws, our co-author Advocate Saurabh Kansal has brought in the much-needed practical approach that is required in application of these laws. Together, we have tried to present comprehensive treatises that could help academicians, judges, lawyers, researchers, students, and anyone who wants to know what the 3 new laws are all about. The task was humongous, But it was made possible by the support of our publisher, Taxmann, Shri Rakesh Bhargavji, and his entire editorial board, who toiled with us day and night to bring out these 3 books in record time. It's a moment of great honor for me, as you have all come here to partake in the unveiling of our books. Thank you. Jai Hind.
Thank you very much, Professor Dr. Deswal. We are privileged to have amongst us one of our senior colleague and a very eminent lawyer, Mrs. Bhambhani. I would request Pallavi Kansal to kindly present. सर हमने ढूंढ लिया, आपने नहीं ढूंढा. जस्टिस बम्बानी सर, आपने नहीं देखा, हमने देख लिया. मिसेस बम्बानी. अच्छा. We're sorry that we saw you late. Sorry. I would request Varsha Singh to present a bouquet to Mr. Pandey, Director Prosecution. Here. I would now request President Delhi High Court Bar Association, Mr. Mohit Mathur, to kindly address the August gathering here.
Honorable Justice Kait, Justice Bhambhani, Justice Manoj Jain, the other honorable judges had their own schedule. Learned Additional Solicitor General, Shri Chetan Sharma ji, Dr. Adish Aggarwala, President, Supreme Court Bar Association, Dr. Reeta Vasishta, Member Secretary, Law Commission, Professor Vageshwari Deswal, Dr. Shruti Goyal, Saurabh Kansal, the authors and team Taxmann, and my dear friends. Taking a cue from what Professor Deswal just said, it's not just an old wine in a new bottle, but with an ethnic label. It's now Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshan Adhiniyam. So, besides the changes, it has a new label to it also. But that apart, this is not the forum for discussing what the law is, how it's good or how it is bad, whether it is with the contemporary world or not with the contemporary world. That's not what we have gathered here for. We have gathered here for our young brother making a debut into the authorship of such serious laws, though with the support of his academic colleagues. But I just had a brief look into the books he sent me across yesterday. What I liked was, besides the tabulation of old and the new provisions, a comparative analysis, was a ready reckoner on the case law given along with each provision. When you look at any book, and especially when you come up and try and read a new enactment, The other day we had a function in which Justice Ori said that even our cinegoers and filmmakers will have to start rethinking from Shri 420 to Shri 318 or something in the 375 will become 63. But that's on the humor side. But as a student of law, when you take any book, pick up any book to read the enactment or to understand the statute, the very fact that it is giving a comparison there itself, on that very page when I am reading a particular provision, it can help me in correlate what was my understanding of that provision of law, and then what's the new change which has come. And additionally, the insertion of the case law relevant to that point. The most important case law is given, obviously, because we have in 75 years several cases. So the most important case law, that gives a good hand to the person who's reading it. It helps him, it aids him in understanding and appreciating that provision immediately. So in this short span, they were able to do this, which takes otherwise years of hard labor. I must congratulate the authors for that. And I, for one, take pride in all such endeavors simply vicariously by saying, he is my member. So I enjoy that my team, my members of my bar are able to do this, and this is something which affects the entire country. And I'm sure it helps in elevating the status of our bar association and our institution, that one of us was able to immediately work on it, because this is the need of the hour, and it will be something which will be required handy from 1st of July. In fact, from 30th June, because 1st of July ke cases kaun karega nahi to understand what is going to happen. So, congratulations, and let's leave the discussion on the sections and the provisions for some other day. Thank you.
Thanks, Mr. Mathur, for a brief perception about these books. I would now request Dr. Adish Aggarwal, President, Supreme Court Bar Association, to kindly address the gathering.
Honorable Mr. Justice Suresh Kait, Honorable Mr. Justice Anup Jairam Bhambhani, Honorable Mr. Justice Jasmeet Singh ji, I think he has left for a meeting, and Honorable Mr. Justice Manoj Jain, Honorable Mr. Justice Suresh, Saurabh Banerjee also has a meeting, Honorable Mr. Justice Jairam ji, who is guardian of all of us, Mr. Chetan Sharma, the most highly respected Additional Solicitor General in India. Not for India, for everyone. But you are the highly respected additional. Yes. And my brother, Mr. Mohit Mathur. Generations have been leader, not only he. And Dr. Reeta Vasishta, Member Secretary, Law Commission of India, and our co-author of this book, from my village, Dr. Professor Vageshwari Deswal, and Dr. Shruti Goyal, and Dr. KPS Mahalwal, who has been the Dean of MD University, for which I fought, and I given permission for National Law School in Gurgaon. And my respected Arun Mohanji, Mr. APS Ahluwalia ji, Sunil Mittal ji, Rajiv Bahal ji, Rakesh Tikku ji, and Rajiv Saxena ji, Madam Nisa Bhambhani ji, Pandey ji, Mr. Hariharan ji, Sachin Puri ji, brothers and sisters in the legal profession. First of all, I congratulate all three co-authors who have written these books in a very, very short time. Actually, when I was called by the parliamentary committee to have views as the president of Supreme Court Bar Association, I welcomed the suggestions of the ministry, but I requested that as government is changing these acts, and every lawyer, every law student, every law teacher is having this IPC, Evidence Act, CRPC, and now you are going to change. This should be provided free to our lawyers. Because when government is burdening us, so our additional Solicitor General, at least you will ask these Taxmann people who have published this book that they should, if Government of India is unable to provide some 50% concession should be given to our members. Our not free of cost, तो ये government नहीं है. जब government is unable to do, how we can expect that can be done by a private publishing house? So this is, it is the duty of the government to provide free. But problem is we are so many lawyers today in the country. Government has also limitation. So, but these things, I think, will be circulated on 22nd of April. On this issue, the Honorable Chief Justice of India, Dr. D.Y. Chandrachud, and our Honorable Union Minister for Law and Justice, they organized one conference, and Chetan Sharma ji was also there, which the lawyers, the Government of India lawyers, the law officers of the country, they given so much information about the changes. And all bar associations in different parts of the country, they are holding meetings, seminars, because it becomes very difficult. When I was addressing the Tamil Nadu Madras High Court Advocate Association, they were saying it is very difficult to pronounce these names. Because for South Indian, it is very difficult when a people like a person born in Haryana. I'm also saying, writing BNS, BNSS, and BSA, it is not easy to pronounce the full name. Because in lawyers, when they're sleeping also, they will remember, they will say IPC, my lord, certain section of IPC or CRPC. So it will take time. So I'm happy that Mr. Saurabh Kansal ji, Dr. my sister Deswal, she is from my native place. And Mr. Kansal also worked with me when he was a student. So we feel so much proud when young people who are very successful in legal profession, people like us who are in different fields, we can spare time. I'm not totally all the time, 24 hours, not for preparing the cases and arguing. We do so many other things in public life. But a successful lawyer like Mr. Saurabh Kansal, when he spares time, that shows how much the legal fraternity is feeling a duty to propagate the new amendments which have been brought by the Government of India. And these are daring amendments. In this, even the judiciary has been compelled to do certain things within a specific time. Otherwise, governments, I salute. the Government of India and the judiciary. The Honorable CJI appreciated these amendments when he was addressing on 22nd of April in Ambedkar International Auditorium. When our judiciary is giving a support to the government, to the lawyers, to educate and telling the benefit of these amendments and new enactments, I'm certain it will change the work culture of our courts and justice delivery system. With these remarks, I am really thankful that I've been given opportunity to talk to you. Thank you very much.
I'm sure the August gathering would appreciate why I said that Dr. Adish Aggarwala is a popular person and a leader, because he would never spare an opportunity to seek largesses for the lawyers, be it from a private operator or from a government organization. Well, I would now request the audience here to warmly welcome Honorable Mr. Justice Anup Jairam Bhambhani and request him to kindly address the author's cabinet. Please, Dr. Anup Jairam Bhambhani.
Honorable Mr. Justice Suresh Kait, Judge, Delhi High Court, Professor Vageshwari Deswal, Dr. Reeta Vasishta, Dr. Shruti Goyal, the leaders of the bar, Mr. Adish Aggarwala, Mr. Mohit Mathur, all other members in this august house, senior counsel, former judges, members of the legal fraternity, ladies and gentlemen. As Professor Deswal said, change is perhaps the only constant in life. In our common law system of justice, in fact, we constantly keep looking at the past because we proceed on the basis of precedent. In a sense, we drive our vehicle always looking in the rear view mirror. What has somebody else done in the past? In such a system, then, along comes a legislation that seeks to introduce wholesale changes in the criminal jurisprudence at a very, very large scale. Now, that can be a good thing, and that can be a bad thing. Now, we are exactly at that cusp, at that moment today, when the three new Sahitas, the Bharatiya Nyaya Sanhita, Nagrik Suraksha Sanhita, and the Sakshya Adhiniyam, have been passed by Parliament, and they are sought to be introduced as of 1st July 2024. Now, we are a very raucous democracy. We are a very noisy people. Sometimes so much that the noise, in fact, drowns out any meaningful debate on any subject. So, as is our wont, debate is raging from both sides. There is one narrative which applauds the new Sahitas. There is another narrative which seeks to criticize them. The critics say, as was said by one of the co-speakers today, that this is just old wine in new bottle, maybe with a new label. But one thing we are certain, that it risks changing the entire vocabulary of criminal justice dispensation. Any practitioner of criminal law will know the way matters would proceed. उनका 161 का बयान पढ़िए. ये तो 164 की स्टेटमेंट थी ना. अब मामला 207 की स्टेज पे है. उसके खिलाफ 81-82 हो चुका है. उनके खिलाफ 751 दर्ज है. And it would take even a rookie lawyer some time to understand that 751 has nothing to do with 7 or with 51, and it's a reference to 107 and 151 of the CRPC. That entire vocabulary of criminal justice dispensation is sought to be overhauled because the laws as they exist are seen as archaic, colonial, and long overdue for such an overhaul. But as Mr. Mathur said, this is neither the occasion nor the time to debate such a thing. The debate is academic. The fact is that the Parliament of India has spoken. Bringing legislation is their exclusive domain. We, as the other pillars of democracy, are now under bounden duty to interpret and to implement the new legislations. Now, the stated objective is, of course, to bring comprehensive reform in our criminal justice system. The idea is to modernize, streamline, and adapt the framework to contemporary standards. The intention is to bring more justice and fairness in the scheme of things, all of which, I must say, are very, very laudable motives. But as someone who has been engaged with the criminal justice system for some time, first as a lawyer and now as a judge, let me highlight some of the problems, some of the serious deficiencies, which all of us as practitioners of the subject would perhaps agree. The first deficiency is the almost complete disregard of the rights of a victim. The victim has never been central to the criminal justice dispensation system. In fact, until very, very recently, the victim didn't even have a voice. He had no right to directly participate in a trial. The second deficiency, if I may say so, is the callous treatment of the rights of an accused. The third is the near complete neglect of the protection of a witness. So hardly anyone can say that a victim, again, was never central, that a witness was always under threat or pressure from either one side or the other, while at the same time the criticism was that we are always discussing the rights of an accused. Now, clearly, therefore, all three dramatis personae in a matter, the victim, the accused, as well as the witness, were not satisfied with the way the system was working. The fourth deficiency, if I may highlight that, was the lack of any sentencing guidelines other than some broad brush directions and guidelines issued in various judicial pronouncements. The fifth was the monumental delay in completion of trials. And the sixth was perhaps the lack of any real recourse for malicious prosecution, where it was often the complaint that even when acquittal came, it only came after suffering years of punishment. And there was a seventh, which was lack of any meaningful victim compensation. Now, do the three Sanhitas address all or any of these deficiencies? Let us do a quick check on exactly what is included in the Sanhitas. As regards a victim, there is a new section 173(2), which entitles the victim to a copy of the FIR. Earlier, the wording was that a copy would be the right to get a copy would be with the informant, but now the word "and victim" is also added. Now, that's a laudable addition. A section 193(3) Roman 2 requires that a victim be informed and kept informed about the progress of investigation. Again, a very big improvement, because as I said earlier, the victim had virtually no role to play once he or she had been victimized. Then there is a section 360, second proviso, to which provides that a court cannot allow withdrawal from prosecution without hearing the victim. I think a very commendable provision, because withdrawal from prosecution at one stage was the prerogative and the decision of the prosecutor. And again, the victim was never asked what he or she felt about the withdrawal. As regards a witness, on a cursory perusal of the Nagrik Suraksha Sanhita, one notices a new provision in section 398, which mandates every state government to mandatorily have a witness protection scheme. Now, earlier there were certain directions issued by the Supreme Court in a case called Mahinder Chawla in 2019, which required that every state should follow a witness protection scheme which had been prepared by the Ministry of Home Affairs of the Government of India, which, however, did not bear much results. So now Section 398 makes it mandatory. How it pans out, of course, remains to be seen. As regards the accused, or an under trial most importantly, the complaint always has been that we keep focusing on the rights of the accused without worrying about what he is alleged to have done. Now, the principle is very simple, that before snatching someone's life or liberty, you have to give the person the fullest opportunity to defend himself. But the delays in our system are well known, and no individual, no institution can be blamed for such delays. The delays are systemic, but they do defeat the rights of the accused. So as regards systemic delays, the Nagrik Suraksha Sanhita proposes stricter timelines for investigation and trial of cases under Section 173. It also adds certain safeguards, such as the mandate to conduct a preliminary inquiry under 173(3) for cases punishable under between 3 and 7 years of punishment. Section 173(3) also permits all legal proceedings to be conducted electronically, again, a measure of updation, keeping up with the times. But as someone who has some trial court experience, I wonder how this will pan out, because we know that in certain aspects of a criminal proceeding, such as cross-examination, the need to capture the demeanor, the hesitancy, the nervousness, or the body language of a person under cross-examination is critical. How far that will be possible in a VC cross-examination remains to be seen. As regards sentencing guidelines, however, on a first blush reading at least, there appears to be nothing either in the Nyaya Sanhita or in the Nagrik Suraksha Sanhita, except that for petty offenses, a new punishment by way of community service has been statutorily inserted. Now, this again is a very laudable move, and in my view, in fact, community service should serve as punishment for several offenses which are perhaps punishable with up to 3 years or less than 3 years of punishment, because it provides a more useful manner of punishing the guilty than just to fine or to confine. There is, of course, the general updation by adding emerging and new age crimes, including technology-based offenses and environmental crimes, which is laudable. However, at the end of the day, one must remember, and I think it was perhaps Nani Palkiwala who said in the context of the Constitution, that a book cannot run a country. What he meant was that no book can run a country, and it is the people who run the book that matter. Ergo, we would all be responsible for improving the criminal justice system, the lawmakers, the lawyers, and most importantly, the judges, on how we interpret the new provisions to keep up with the times, while at the same time maintaining the essence and the purpose of the new legislation. I must compliment the authors, Mr. Saurabh Kansal, Professor Vageshwari Deswal, and Dr. Shruti Goyal for their effort in putting together these volumes, which Taxmann has very professionally published I'm sure these volumes would be a very valuable addition to any legal library. But it is hard to deny, and I must say so quite candidly, that the seed of what has been recodified in the new Sanhitas was already there, even in the existing criminal laws. However, experience has it that the seed never really germinated to bear fruit. The seed has now been replanted by Parliament. We must respect that, and let us see how it grows. Ending on a sanguine note, therefore, I would hope that the new effort fares better than we have in the past. Before I close, however, I must also say that with the expanding interest in criminal justice reform, as is reflected by the enactment of the new Sanhitas, there is also need in our own institution in the Delhi High Court to go beyond the commercial. If I may say so with utmost respect, beyond the rich man's jurisdictions, beyond having a commercial division and an intellectual property division, all of which are doing stellar work and are welcome. But perhaps it is also time for the Delhi High Court to lead the way by now having a human rights division, both to implement the new Sanhitas and also to redress grievances of other human rights violations which come our way through habeas corpus petitions, child right matters, matters relating to mass encroachments on state land, matters relating to refugees and other similar cases involving personal liberty and freedom. I would commend this suggestion of creating a new human rights division in the Delhi High Court for the consideration of our Acting Chief Justice and other senior judges of the High Court. With those words, I thank you for your attention and I compliment the authors and the publisher, and may this lead to further revisions and further editions of the books. Thank you so much.
Thank you very much, Honorable Justice Bhambhani, for a very analytical insight into the amendments for the benefit of each one of us here, especially for non-criminal law practice lawyers like me. I would now request you all to kindly give a standing ovation to our Chief Guest, Honorable Mr. Justice Suresh Kait, and request him to kindly address the august gathering.
First of all, thank you very much, all of you, to give me standing ovation. And those who are sleeping, I want to convey them that when you come to a function where you don't know who is the organizer, who is the guest of honor, who is the chief guest, for the reason from one to last almost, all are from Haryana as narrated by Adish Aggarwala. and वो हरियाणा में की एक आदत है कि थोड़ा सा जो भी नाम है सीधा सीधा उसको थोड़ा तोड़े मरोड़ेंगे ज़रूर. उसका सबसे बड़ा उदाहरण तो आदिश अग्रवाला, सब जगह अग्रवाला ही ना अग्रवाला किया. अभी जब ये भारतीय न्याय संहिता एक का फ़ोन आता है कि ये भारतीय न्याय संहिता कैसी है. मैंने कहा है भारतीय न्याय संहिता है. कहता हाँ संहिता ही बोल रहा हूँ. तो जब दोबारा बोला तो मेरे पास कोई चारा नहीं था यह कह के हाँ हाँ अब ठीक बोल रहा है. तो यहाँ अभी आप देख रहे होंगे फोटोग्राफर भाई को कितनी अच्छी सजेशन दी आदिश अग्रवाल ने कि कैसे खींचने ताकि इनकी फ़ोटो जरूर आए. तो उसकी अच्छा दूसरा ये फोटोग्राफर भी उनकी बात नहीं कर रहा जो पीछे, मैं इनकी बात कर रहा हूँ भाई की. अब पहले आप अगर देखें फोटोग्राफर खुद मूव करता था इधर से उधर, वो देखता था किस एंगल से फ़ोटो लेनी, उसको पता होता है. अब उसको कोई जरूरत नहीं, वो कहता इधर देखो, उसमें कौन किसको दे रहा, कौन किसे ले रहा, कुछ पता नहीं। पहले पता होता था कि ए प्रेजेंटिंग टू बी और बी रिसीविंग समथिंग। तो अब ये सब, जबकि पहले कितने तब रील थी लिमिटेड, उसमें पता 36, 34 वट एवर दी पिक्चर्स यूज टू कम। डिस्पाइट दैट दे वर वेरी अलर्ट एंड एक्टिव। अब ये जितनी मर्जी खींच लो, जितनी मर्जी डिलीट करो, तब भी ये खिसक के राजी नहीं अपनी जगह से। एनीवे, दिस सजेशन इज गुड फ्रॉम, नॉट फ्रॉम माई साइड, फ्रॉम आदिश अग्रवाला साइड। Anyway, my esteemed colleague Justice Bhambhani and Mrs. Bhambhani, there are two judges, those who are bunker in the classes, and today also they did, Justice Jasmeet and Justice Saurabh Banerjee, and Justice Manoj Jain is very much there, he never bunked the classes. Justice Midda, our very dear colleague, I don't say former colleague, still colleague, and he is a teacher, professor, senior, everything. So I also written his name in that category, but somehow he has now occupied the chair. Thank you, sir. So nice of you. This additional Solicitor General Chetan Sharma, he is also from Haryana. Only this Yamuna is in between, that's all. Mohit Mathur, President of the Bar. Adish Aggarwala, President of Supreme Court Bar, the highest bar of India. Dr. Reeta Vasishta, Professor Vageshwari Deswal. Everybody knows now that she is from Haryana. This Justice Bhambhani was thinking that she may be Punjab or Rajasthan. But now he has cleared that. Thank you, you all. And today, we are discussing the significant changes brought about by the new criminal laws in India. These criminal laws, namely, Bharatiya Nyaya Sanhita 2023, Bharatiya Nagrik Suraksha Sanhita 2023, and Bharatiya Sakshya Adhiniyam 2023, replacing the Indian Penal Code, Criminal Procedure Code, and the Indian Evidence Act, respectively. It's aimed to revamp and replace of British-era laws. They aim at completely overhauling the criminal justice system in country. Focus is on delivery of speedy justice, and the other main purposes of these laws are to include the principle of natural justice more comprehensively, to simplify the procedure and to keep it technology friendly, to prevent delay in investigation and trial, and to do balancing of interest between the parties. We all know that laws are always in the process of evaluation in order to make the process of dispensation of justice more effective and suitable to the present societal requirements. These newly introduced laws are more in line with constitutional essence, that is, it is more explicit about the safeguards in process of justice. Bharatiya Nyaya Sanhita 2023, BNS, replaces the colonial era Indian Penal Code. It aims to modernize and update criminal provisions to better address temporary challenges and reflect Indian ethos. It consists of only 358 sections as opposed to 511 sections in IPC. Some salient features of this law are: 1. The offense of sedition is eliminated. Instead, BNS penalize acts that excite subversive activities or endangering the sovereignty, unity, and integrity of India under Section 152. The focus is on protecting citizens' right to criticize the government while discouraging acts against the nation. It is noteworthy that under Section 4 of BNS 2023, community service has been introduced as one of the punishment for the first time. It introduces the reformative approach in the punishment scheme, which is aimed towards achieving justice in the society. Also in section 69 of BNS 2023, a new offence for having sexual intercourse on false promise of marriage, employment, promotion, or by expressing the identity, etc., has been introduced. This provision will create deterrent effect for especially the people who employ deceitful means like false promise of marriage, concealing identity, etc., to take consent of a woman to indulge in sexual activities. The offence of snatching was not present in IPC 1860, but has been introduced in BNS 2023 under section 304 to curb the menace of snatching. A separate chapter, that is chapter 5, is explicitly dedicated to women and children, consisting of stringent provisions. The act of hiring, employing, or engaging a child to commit a crime is also made a punishable offence. To tackle organized crime and terrorist act, new definition of terrorism and organized crime has been incorporated for the first time under section 113 and 111 respectively. Mob lynching is also made an offence explicitly under section 103(2). The offence of attempt to commit suicide has been deleted in BNS 2023 to bring it in the line with the Mental Health Care Act 2017. A new section 226 has been added to commit suicide with the intent to compel or restrain the exercise of any lawful power by a public servant. The definition of child and transgender is included in section 2 of BNS 2023. Bharatiya Nagrik Suraksha Sanhita replaces the Code of Criminal Procedure. This law focuses on procedural aspect of criminal justice. It aims to streamline investigation, prosecution, and victim protection. Some features are that integration of technology in criminal procedure. Section 21A of the BNSS defines audio, video, electronic means to provide for its use at various stages of criminal investigation and trial. The BNSS also seeks to introduce various timelines to ensure time-bound investigation, trial, and pronouncement of the judgments. Custody of arrested persons during investigation, that is section 187(2), provide that definition in custody of 15 days in whole or in part can be at any time during the initial period as prescribed under section 187(3) of BNSS. Provisions pertaining to bail and bond. This act, by way of introducing section 479(1), reduces the maximum period of detention for under trial prisoners who are first-time offenders to 1/3 of the maximum period of imprisonment that is specified for such offence. The Parliament has tried to do balancing of interest between accused on one hand and society on the other. It broadens the scope of medical examination, allowing any police officer, not just a sub-inspector, to request one, making the process more accessible. It also mandates forensic investigation for crime punishable by at least 7 years imprisonment. Regarding Bharatiya Sakshya Adhiniyam, this replaces the Indian Evidence Act 1872. The BSA introduces changes to evidence collection, admissibility, and presentation to the court. It also aligns with modern practice and the technology. Definition of secondary evidence expanded. Section 58 of BSA defines secondary evidence and expand it to also include oral admissions, written admissions, and testimony of a person who has examined the document and is skilled in the examination of documents. Under Section 24, the BSA incorporates an explanation to joint trials. The section states that where multiple persons are tried jointly for the same offense, if the accused who has absconded or who failed to comply with the proclamation issued against him is absent during the trial will be conducted as a joint trial. The significant changes have been introduced in this act to leverage the use of technology in collection of evidence and recognize contemporary technological practice where information is distributed and stored across various platforms in various forms. Scope of admissibility is expanded to take into account digital evidence and record and to strengthen investigation where in the old criminal laws the electronic evidence had limited admissibility. Section 52 of BSA 2023 enables the court to take judicial notice of laws having extraterritorial operations, international treaty, agreement or convention with countries or decisions made at international associations or other bodies, tribunals, state legislatures and the territory of India as opposed to the territories under the domain of the Government of India. Some potential effect that can be brought about by these new criminal laws would be protection of victim and witnesses. It aims to improve protection for victim and witnesses, including the introduction of witness protection schemes. Streamlined procedures under the Bharatiya Nagrik Suraksha Sanhita may expedite investigations and trials. Faster justice delivery could discourage criminals and enhance public trust in the legal system. Modern criminal law may impact social perceptions and attitude towards certain behaviors, for example, discriminalization, certain activities, or adopting restorative justice practices may change public opinion towards rehabilitation rather than the punishment. The acts demonstrate a commitment to provide enhanced protection for marginalized and vulnerable segment of society, aligning the criminal justice system with current needs and values. The three acts underscore India's commitment to reform its legal framework in the present era. These reforms are a significant step towards modernization India's criminal justice system and addressing the challenges of today's society. One of the biggest challenges in our criminal justice is delay. Justice delayed is justice denied, and the lawmakers have framed these laws keeping this in mind. The best aspect of done by the author is that in all the books I have gone through, they have made 5 tables at the initial stage. In Bharatiya Nagrik Suraksha, rest of all, what they made, the first table showing sections of the old act and the new act and vice versa. Second, the third table is showing new sections of the present one and the old one. Fourth table showing the CRPC 73 replaced by BNSS 2023 and section key to the present one and subject to the other one. So therefore, these all in one go if you go, you can see, suppose 302 you want to see, you can just refer 302 because that table is there. Opposite to 302 you will see 103 is the new section. But initially, as Justice Bhambhani has pointed out, it will be difficulty which section is, which is 161 statement, was 164. So it is a big challenge to the criminal lawyers and the judges who will certainly do in the criminal side. With these all words, I congratulate the all the put hard work, especially the Professor Deswal, Kansal, and Madam Gupta. She is sitting on the first row. Very senior advocates are there. And thank you very much for giving me the opportunity. All the best to all of you, and thank you very much.
Thank you, Honorable Justice Kait, for a wonderful insight and a very detailed academic guidelines to the amendments. And now, for our ebullient, Honorable Additional Solicitor General, Mr. Chetan Sharma, to sum up the amendments and also to consider the request from our brother Adish Aggarwala with regard to the discounts from the Government of India.
नमस्कार, आप सब का बहुत स्वागत है. Book launches by an advocate is a very big event, as Mohit ji says. To use a pun, it raises the bar. The bar is proud, Delhi High Court Bar Association is proud to have our good friend here, the author. Please give a round of applause for him. ये छोटी बात नहीं है. आज जब 3 सफ़े भी लिखने होते हैं तो सिर में दर्द हो जाता है. इतनी बड़ी किताब लिखना, उसका इतना विश्लेषण करना, उस पे इतना मंथन करना और उसको इस क्रिस्पनेस से प्रस्तुत करना, जैसा कि मोहित ने बताया कि कंपैरेटिव सेक्शंस को साइड बाय साइड लेके, ताकि वकीलों को दिक्कत ना हो. Otherwise, you see, you don't have much of time. You are working till 30th of May, and then you'll go off on a holiday. And 1st of July, say, you will have to look at section 363. You will have to look at 173. You will have to look at 562. They are very, very different and new path-breaking sections. तो सबसे पहले प्रोटोकॉल का निर्वहन करते हुए Honorable Justice Suresh Kait, he has been so kind and benevolent to have come here, spared his very valuable time. So हम ताली ज़रूर बजाएंगे कैद साहब के लिए. और देखिए, आप लोग बड़े कुछ थोड़े से गम में बैठे हुए थे, लेकिन जैसे सुरेश साहब आए हैं, आप सबके चेहरों पर एक मुस्कान है. ये कितनी बड़ी बात है. ये वैसे आपकी बात ठीक है सर, पार्टली हरियाणा कॉन्क्लेव है ये. Our esteemed Honorable Justice Anup Bhambhani Sahab, I call him the juristic doctrinaire approach, neutral doctrinaire approach judge. He is known for for the standards that he sets for himself and pursues those with immaculate intellectualism, if I may say so. We welcome you, sir. 2 judges in absentia who have been termed as, I can't use the word, I'm still a lawyer, but they came, it's so nice of them. Justice Manoj Jain, the model judge who is sitting in front of us. I must acknowledge my guru, who is here to bless us all, the legendary and iconic Shri Arun Mohanji, senior advocate. There are few parallels in civil law that can ever be had than the legend who is sitting before us. He has authored the Civil Procedure Code, he has dissected them, and in जैसी drafting और in जैसा दिमाग civil law में मुझे नहीं लगता कि on all fronts he's a real treasure. I welcome you, sir, with folded hands. I started with him in 51 Sundarnagar. Justice Midha is here, जिनको मैंने गाइडलाइन जज भी बोला था उनके फेयरवेल पे. जजमेंट लिखना बहुत एक अपने आप में बड़ा एक सार्थकता की विषय है, लेकिन उसके साथ लॉ को इवॉल्व करके गाइडलाइंस देना रिक्वायर्स अ ग्रेट इंटेलेक्चुअल डेप्थ, and that is why the cosmos is rewarding him in the way it is. We have amongst us senior advocates, Ahluwalia Saab, very, very respected senior advocate of this bar, who is always there to lend his gracious presence in such functions. Shri Hariharan Saab, leading criminal lawyer, who is here, and also an aspirant now for the future forthcoming polls. I have not. Shri Sachin Puri, the prosecutor Pandey Saab, जिनको एक छोटा सा प्लांटर बिल्कुल साइड पे प्रस्तुत किया गया. Of course, we cannot miss. अगर मैडम jointly and severally है, then you are welcome with Justice Bhambhani. So there's बहल साहब हैं, बाकी सारे आप लोग हैं. अगर मैं यही करता रहा तो सेक्शंस रह जाएंगे, सिर्फ नाम ही रह जाएंगे. But be that as it may, the summing up is this. Number one, from penal, from inflictment of punishment, this is a justice-oriented, न्याय संहिता है. ये justice-oriented है. ये परिवर्तन है. From the British, who had a mindset to subjugate the Indians, उनको डराना, उनको अपने कानून से नीचे दबाना, उनको महसूस कराना कि they are subjects, they are the ruled, they are slaves, and they'll be taken to the strictest sense as to how the British will inflict. From that, the regime has now shifted to even-handed justice. उस even-handed justice में जो आपने बात स्वीकारी है, वो 173 में, और उसको आप मिलाओगे 562 के साथ, 561 के साथ, तो ये एक बहुत बड़ा शिफ्ट है. अब आप किसी थाने में जाएंगे तो आपको वहां पुलिस ये नहीं कह सकते कि हमारा जुरिस्डिक्शन नहीं है. आप वहां जाइए या जहां भी मर्जी जाइए, आप कहीं भी हो, जिस भी थाने में आप जाओगे, you will, the police is now mandated to register the FIR. It will be a 0 FIR, and then it will be transferred to the proper jurisdiction. But now the police has got no say to say that हम नहीं करेंगे इसको. इससे बहुत बड़ी राहत मिलेगी. फिर ये विक्टिम, जैसे जस्टिस बंबानी ने बताया, विक्टिम को कभी सुना नहीं जाता था. राधेश्याम वर्सेस स्टेट, दैट्स ऑल. अब स्टेट जो करे ना करे, स्टेट कुछ भी करे या ना करे, वो चीखता रह जाता. साहब मुझे सुन लो, तेरा रोल कोई नहीं, अब तो स्टेट करेगा. तो जो द पर्सन हु इज अफेक्टेड बाय द क्राइम, अगर उसका रोल ही ना हो तो वो किस बात की संहिता है वो. तो ये जो नया कानून आया है, दिस हैज ब्रॉट इन दिस मेजर चेंज ऑफ द अक्यूज्ड बीइंग हर्ड. अक्यूज्ड को नेचुरल जस्टिस दी गई है और विक्टिम को पार्टिसिपेटरी राइट दिया गया है. Not only for the copies, but also participatory in the process. This is a big shift. So इस बात को मुझे आपसे सामने हाईलाइट करना था. बाकी तो आप पढ़ेंगे, और अगर मैंने सारा कुछ बता दिया तो फिर आप कम पढ़ेंगे. इसलिए you must delve into it more. Now time is getting over, but मैं सिर्फ इतना कहूँगा कि भारतीय न्याय संहिता, भारतीय नागरिक सुरक्षा संहिता और भारतीय साक्ष्य अधिनियम, इनमें उच्चारण में आपको कोई ज्यादा दिक्कत नहीं होने वाली, चाहे आप हरियाणा के हों या नहीं हो. ये दिस इज द चेंजिंग टाइम. एज जस्टिस बंबानी सेड, द ओनली कांस्टेंट इन लाइफ इज चेंज. वी वर स्टक अप विथ मैकॉले, वी वर स्टक अप एट 1872, लिटिल रियलाइजिंग दैट वी आर इन 2024. तो ये परिवर्तन है, ये परिवर्तन चलता रहेगा. एंड इन सो फार एज द डिस्काउंट पार्ट इज कंसर्न, आई हैव टू एड्रेस दैट ऑल्सो. आदिश साहब का, और मैं आदिश जी आपका मैं बड़ा कृतज्ञ हूं. आज तक मुझे किसी ने ये नहीं कहा था कि साहब मैं कि इतना कोई रिस्पेक्ट है, मैं तो सबको एक प्रेम भरी नज़र से देखता हूँ, मुझे लगता है कि सारे मुझसे भी प्रेम करते हैं, ये आप लोगों का उदारता है इस तरह से। और आपका मैं बहुत बहुत अभिवादन और धन्यवाद करता हूँ कि आपने ऐसे सुंदर शब्दों के लिए और ऐसे भावप्रद भावों के लिए मेरा आपने अभिनंदन किया। मैं
कभी झूठा नहीं करता, असलियत बोलता हूँ। लिख के लेके गए थे, लिख के जो असली होती है नाम मैं लिख लेता हूँ, हर एक को भूल नहीं जाऊँ तो दिक्कत हो जाती है बाद में, मुझे मेरा नाम नहीं बोल रहा, इसलिए नाम लिख लेता हूँ। देखो
ये सच्चाई है। इन्होंने फोटोग्राफर को क्या कहा, भाई उधर ना देख, इधर खींच, तो ये कौन कहेगा, ये सच्चा आदमी तो कहेगा ना, जो झूठा होगा वो इधर उधर करेगा, ये तो सच्ची बात करने वाले आदमी। एंड नो वंडर ही इज अ वेरी लव्ड एंड very fondly wanted president, and this also signals a change in the system. The ascension of Mr. Aggarwal to the office of the President of Bar Association Supreme Court also signals, and I'm saying it, a welcome change. The authors need to be applauded. Insofar as the discount part is concerned, let me be very candid. अगर मंत्री जी होते तो यहीं हो जाता। अब मंत्री जी किसी कारण नहीं है, तो आप एक representation type लिख दें, क्योंकि ये नए कानून हैं। And you know the books are तीनों किताब जो हैं they are quite bulky. तो मंत्री जी को एड्रेस करते हुए आप मुझे उसका कॉपी दें, मैं अपने लेटर हेड पे मंत्री जी को उसको एंडोर्स करते हुए भारत सरकार को ये रिकमेंड करूंगा कि हमारे जो वकील हैं दे आर वेरी रिच बट स्टिल
करना चाहते हैं,
हाँ, बट स्टिल क्योंकि इनको इसको आगे डिस्पर्स करना है, ज्ञान अपने तक नहीं रखना है, आगे डिस्पर्स करना है। क्योंकि चीफ जस्टिस साहब ने 22 अप्रैल को जो बात कही उसमें दो चीजें कही थी। एक कि हमने फ्रेमवर्क तो बना दिया, नाउ द प्रॉब्लम इज ए एग्जीक्यूशन एंड बी डिस्पर्शन टू द रिमोटेस्ट पार्ट्स ऑफ इंडिया जहां ये कानून जो है वो लागू होंगे। सो जहां फोरेंसिक और वीडियो और डिजिटलाइजेशन है, वेदर इट विल रीच एंड हाउ इट विल रीच द रिमोटेस्ट पार्ट ऑफ द कंट्री and also the marginalized members of the society. Let me tell you, इस कानून में there is a specific provision which deals with the marginalized sections of the society which do not have access or which should have more access to the justice as it prevails today. So that is very egalitarian. ये बड़ी सार्वभौम है। और इसमें मंत्री जी ने कहा था उस वक्त कि जब सोलिसिटर जनरल साहब ने बोला, उन्होंने इस कानून की धाराएं की बात की थी कि उन्होंने कहा मैं धाराएं के साथ इसकी धर्म और इसकी धरा की भी बात करूंगा। तो ये बहुत बड़ा एक 22 अप्रैल को जो अधिवेशन हुआ था उसमें ये बात हुई थी। मैडम वागेश्वरी जी, आपका भी बहुत बहुत स्वागत है। आपका तो नाम सरस्वती से ही मिलता है, वागीशायस्य वदने, तो वागीश सरस्वती को कहते हैं। उन्होंने वाकई में आपने जिस प्रकार से हमारे छोटे भाई की जिस सहायता की और जिस प्रकार से आपने किया, आपका भी बहुत बहुत अभिनंदन। आप सब इसको पढ़िए, इसको गुथिए, इसका मनन कीजिए, स्तवन करिए, निधिध्यासन करिए, स्वाध्याय कीजिए, आपको बहुत अच्छा लगेगा। The authors need to be complimented. Round of applause for them. A round of applause for you who are so alert at 7 p.m. after doing a good job in the courts today. Dhanyavad. Jai.
Thank you very much, Chetan bhai. And now, I am sure everyone at the dais and in the auditorium must have been wondering why we had a lamp here on the dais, but we have not lighted it. I am very sure about that. Yes, just as Justice Bhambhani has just said, change is the only constant in the life. This is the change we were looking for today. We have heard the genesis of the amendments to the cardinal codes of legal principle. We have had a very detailed insight by the deliberations from Honorable Justice Bhambhani. We have had a very analytical insight by the deliberations of Honorable Justice Suresh Kait. We have also had the privilege of understanding the law as it has been evolved by way of these amendments from Mr. Chetan Sharma, Mr. Mohit Mathur, Professor Vageshwari, and Ms. Dr. Reeta. And now, before we launch and unveil the books, we launch these books that will benefit each one of us. Now, we will request the dignitaries on the dais, Honorable Mr. Justice Jagjivan Ram Midda, Mr. Justice Manoj Jain, and our Dr. Arun Mohan and Mr. APS Aluwalia to kindly join the lighting of lamp on the stage for invoking the blessings of the Almighty for all of us to implement these amended codes in our profession. Please, sir. Criminal lawyer, Mr. Hariharan. So sorry, I missed it. Yes. मैं सर सिविल लॉयर हूँ इसलिए जरा थोड़ा भूल जाता हूँ क्रिमिनल लॉयर. लाइट करो. Please. Dr. Shruti Goyal, please, on the stage. Yeah, please.
किसी की तालियां नहीं बज रही, यहाँ तो बजाओ.
I would request Raghav to kindly escort Justice Manoj Jain, and your colleague to kindly escort Justice Midha to the stage for the launch of the books. And Mr. Arun Mohan. Dr. Arun Mohan, please, sir. Pallavi, please. So sorry. Dr. Preeti Aggarwal, please. With the blessings of Almighty having been invoked, Om Saraswati Devaya Namaha.
बेटा साहब पर इधर आओ बेटा साहब प्रोटोकॉल को मत तोड़ो बस आप इधर आओ
A good round of applause for a wonderful presentation. Nice publication by Taxmann. Congratulations to the authors and also to the publisher for a good work done in larger public interest. Thank you very much for all of you for kindly bearing with us and waiting for so long for last 2 hours. Thank you very much, the dignitaries on dais. And I would now hand over the mic to none other than our author, the hero of the day. I am told that Honorable Mr. Justice Waziri has very quietly come in and is sitting at the back. May I request Honorable Justice Waziri to kindly, Vidhi, please escort Justice Waziri to the stage, please.
एक जन जाके लाओ
We are so thankful to you, sir. Sir, please. Here, sir.
यहाँ से रास्ता इधर आने का
I am so sorry. I was just told that. Sir. And now, ladies and gentlemen, brothers and sisters, the final word from the author to be spoken, not to be read in the book.
Thank you, sir. A very good evening to all of you. I think my quota for appreciation is full today for another 6 months. Honorable Mr. Justice Suresh Kait, thank you so much, sir, taking out time. I still remember my first day in the court when I was appreciated in the court, and it keeps us going, sir. That was the day which I still remember. I argued a matter, whatever was the outcome, but Honorable Mr. Justice...
You could not get the favorable...
Sir, in fact, I could say that I got a little more. It was one of those ABCD matters wherein I got a little more in another's appeal because I had those judgments. I happened to assist Honorable Justice Midha in that roster in those days. So yes, I was very well equipped. So sir, that keeps us going, that supports us. I'm so grateful that you were there to encourage me that day, and you are here today as well, sir. I'm so grateful. Thank you. Honorable Mr. Justice Bhambhani, I remember those days of briefing, sir. I am so grateful you could spare some time. I've learned a lot from sir. Various matters I happen to assist, and I continue to do so. sir's passion for development in the criminal laws, sir's suggestions of establishment of a new division. We hope it will happen under the aegis of this Honorable High Court, sir. I am so grateful you could take out the time. Honorable Mr. Justice Manoj Jain, I am so grateful, sir, that you have taken out time and joined us. Reeta Vasishta, ma'am, Member Secretary, Law Commission. Ma'am, I am grateful that you have taken out time at such a short notice. Mr. Mohit Mathur, sir, President, Delhi High Court Bar. Sir, I am surprised that we had the book sent to you yesterday evening and you could go through them. I understand those provisions a little better now after you have elaborated. I am so grateful, sir. Chetan Sharma, sir, Honorable ASG, sir. I understand a lot of responsibility has been put on me if I have raised the bar. I ensure we'll keep it up, we'll do the good work, we'll try to raise it further, sir. But it could happen only because you are our leaders. We look up to you people, sir. So I'm so grateful that you have come here, encouraged us to keep it up, sir. Dr. Adish Aggarwala, sir, thank you, sir. I remember those days when I was not even a lawyer and sir had helped me in those days. Sir was there when I was enrolled. Honorable Mr. Justice Waziri, I am so grateful, sir. I happen to assist, sir, in many of those matters, and I proudly say that in one of those matters when we did the social audit of the Delhi roads, I could assist, sir. And I'm sure, sir, the Delhi roads, many of them are too good because you were hearing those matters. Dr. Vageshwari, Deswal, I'm so grateful to have you on board, ma'am, with these books. It couldn't have happened without your insights. Dr. Shruti Goyal, Shri SM Goyal, sir, you are here. We are really grateful that you have traveled all the way from Patiala here today. Adish, sir, we are here, two Punjabis. Goyal ma'am is from there. I happen to be there. But of course, it's Punjab and Haryana now. Agreed, sir. It couldn't have happened without my team at BNS Associates as well. Dr. Arun Mohan, sir, I still remember those first principles. I always argue. I usually use the word that we have to assess the Honorable Court on the first principles of law. I try to do that. I am grateful that I could be there under you as well. And learned ASG, sir, I would say that I happen to be much younger but a Guru Bhai because after Justice Midha, I joined Dr. Arun Mohan for a very long time and I continue to assist him, sir. Shri Hariharan, sir, I am thankful to you, sir. I understand you are too busy that you're still here. Shri A.P.S. Aluwalia, sir, Sachin Puri, sir, my team at BNS Associates who have worked so hard. Last and not the least, my lovely wife, Pallavi, because... No, I said it, sir. I couldn't have started because I was with Justice Midha. I was born in this profession with Justice Midha, so I couldn't have been here without him. Pallavi, thank you so much. You'll have to keep me grounded now after so much of applause today. So please do that. And thank you, Rajiv Saxena, sir. We couldn't have a better person there to have it run smoothly. Thank you so much, sir. And I won't hold you here. I hope this work helps everybody. Thank you, Taxmann Publications. Wonderful publication done. Of course, whatever work, little work we could do, but wonderful publication. And the team from Taxmann who's here. Thank you so much. May I request everybody to join us for the high tea? Please, it's a long time. I'm sure everybody would love to have some lovely refreshments now. Please come. Please come. Manish, please come.
माथुर साहब जरा आप वही तो हम बैठेंगे आइए सर आप इधर मैडम नहीं आप बैठना है